Okay, thanks.
All right, good morning, everyone. Today is Friday, March 8th, 2024. We're going to work off of voting list number 9. And we're going to start off with Shamari with Senate Bill 49.
Yep. Senate Bill 49 alters statutory provisions.
Sorry, Shamari, my apologies. 439, my apologies. Is that Shamari?
That is.
Yep, that is
Jamie.
That's me. Senate Bill 439 establishes the Victims of Domestic Violence Grant Fund, a special fund administered by the Governor's Office of Crime Prevention and Policy, and provides grants to public or private nonprofit comprehensive domestic violence programs certified by the federally recognized State Domestic Violence Coalition. The governor may include in the annual budget bill an appropriation of $5 million for the fund. The bill further requires domestic violence programs as established under existing statute to be certified by the federally recognized State Domestic Violence Coalition as a comprehensive domestic violence program.
There are no amendments.
There are no amendments.
This does need B&T approval, so we're cross this line, so it doesn't. We have to vote it, and then they have to vote it. So, just open.
It's an egg.
Further discussion? All right, motions were favorable. It's been seconded. Is everyone okay being recorded in the affirmative for Senate Bill 439? All right, 439 passes unanimously. I'm gonna go to a couple of these local bills. Senate Bill 450, that's Josh.
Senate Bill 450 authorizes a placement of speed monitoring systems in Baltimore County on highways and residential districts with a maximum speed limit of 35 miles an hour, subject to specified existing signage and placement requirements. There is an amendment in your packet from the delegation. That's amendment number 103824/1. This would make several changes to the bill. First, it would require revenues after cost recovery from the speed monitoring systems to be used for placing traffic calming devices in Baltimore County. It would require the Baltimore Police Department to consider the racial and socioeconomic impact of systems before placing them. It would create some procedures for ensuring that citations are mailed to the right address and that the vehicles who are recorded committing violations are not stolen. It would require an annual report on the citations issued, and it would sunset the bill after 10 years.
Senator Sidnor, do you want to speak on it at all, or since from delegation?
The letter should be there. How we ask for favorable.
Okay, so the amendment has been moved. It's been seconded. Is that okay adopting amendment 103824/1? All right, everyone is okay. Now the bill is before you as amended. Further discussion?
Move favorable.
Senator Sidnor moves favorable. It's been seconded. Is everyone okay being recorded in the? All right, let's do Senator Holden down.
Okay.
You're down. Baltimore counties. This is the one you like. You do. This was the one you said, man, they should be doing this for all of the speed cameras. You forgot that conversation. Remember, this is the one with the traffic studies that gotta be used.
All right, Senate Bill 450 passes 10-1. All right, with amendment. Now let's move on to Senate Bill 562. That's Shamari.
Senate Bill 562 establishes the work group to study the salary of the sheriff of Frederick County. The work group must study the salaries of the sheriff in each county in the state and other law enforcement positions with similar responsibilities and preparation requirements as a sheriff. And two, make recommendations regarding the salary of the sheriff of Frederick County. The work group members must elect a chair, the legislative liaison of the county executive of Frederick County in consultation with the staff of the members of the work group, and must provide staff. Members may not receive compensation, but are entitled to reimbursement for expenses under the standard state travel regulations by December 15th, 2025. The work group must report its findings and recommendations to the Frederick County delegation to the General Assembly.
In spite of my friend voting against my local bill, I'm gonna vote with him.
All right, so no amendments, correct?
There are no amendments.
All right, there's been a motion for favorable, it's been seconded. Everyone is okay being recorded in the affirmative. Senate Bill 562 passes unanimously. Now go on to Senate Bill 643. And that is Shamari's.
Oh, I'm sorry. Sorry, can we come back to that one? I don't have that one up.
Sure, no problem. All right. I'm gonna go, hold on. Who's 965? Who's got another one? Who has 965? All of these are Shamari.
I
What
have
about
965.
1038? What about 1038?
I have 1038 as well.
Okay, are you good to go on those?
Yep.
Okay, let's do 1038 and then we'll go 965.
Senate Bill 1038 specifies that if a person fails to obey a subpoena served by the Anne Arundel County Human Relations Commission, the individual authorizing the service of the subpoena may authorize the individual serving the subpoenas to certify the default to the clerk of the court. Non-certification on the default, the clerk must issue a body attachment to the sheriff against the person named in the subpoena, returnable on the date specified in the attachment to compel compliance with the subpoena. There is a delegation letter in your packet.
All right, there's been a motion for favorables and the second is open for discussion. We have a delegation letter, you said?
Yes,
No amendments.
no amendments.
All right. All right, is everyone okay being recorded in the affirmative? All right, Senate Bill 1038 passes unanimously. Shamar, are you ready for Senate Bill 965?
Yep.
Senate Bill 965.
Senate Bill 965 alters the annual salary of the sheriff of Carroll County to be equal to the salary of a Department of State Police lieutenant colonel at the highest available step for a lieutenant colonel under the Department of State Police pay plan beginning in 2026, and providing for a certain change in the annual salary of the sheriff of Carroll County under certain circumstance for each term of office of the sheriff. And there is a delegation letter in your packet. No amendments.
Motion for favorables and second, is everyone okay being recorded in the affirmative? All right, Senate Bill 965 passes unanimously. Are we ready to go with Senate Bill 688? Or you need some more time?
643 or 680?
Sorry, 643, that's the Baltimore City?
So Senate Bill 643 repeals a provision of law requiring a custodian to deny inspection of certain surveillance images of illegal dumping in Baltimore City. There was an amendment by the sponsor. It's not yet completed, but I can explain it. It's just one line if the committee's willing. And so instead of repealing the entire section, the amendment just adds to number 4, and it'll read by an employee or agents of the Baltimore City Department of Housing and Community Development in an investigation or proceeding related to the imposition, relating to civil liability under 10-112 of the criminal law article. And so what that does is it allows the Baltimore City Department of Housing and Community Development to share the images. It's a question of whether that is entirely necessary under current law. However, this just makes clear that the images that the Department of Housing and Community Development captures on their cameras can be shared with the public in the effort of trying to catch illegal dumpers. And so
this bill, Senate Bill 643, it basically strikes out a section of law. That's all it does. So what are we amending?
So we're striking the brackets and keeping the section
Oh,
in
we're
law.
striking the bracket.
Yes.
Okay.
And this section of the code only applies to Baltimore City because surveillance images as defined in 10-112 just is in regards to Baltimore City enforcement of illegal dumping. And so what the amendment will do is it'll strike the brackets, maintaining the general law as it relates to inspection of those surveillance images, and instead just permits inspection by the Department of Housing and Community Development so that they can use the images and share them with the public.
And we have a letter on this one?
There is a letter. It's not in the packet, my apologies, but we do have a letter from the Baltimore City delegation.
Okay, great.
All right. Move favorable.
As motion moved to adopt the amendment. Now the bill is before you as amended. Senator Carter, I'll defer to you. Okay, excellent. Motions were favorable on the bill as amended. Is everyone okay to be recorded in the affirmative? All right, Senate Bill 643 passes unanimously with amendment.
We have a letter.
All right, Senate Bill 688.
Senate Bill 688 alters the number of resident judges of the circuit court by adding 1 additional judgeship in Prince George's County. There are no amendments.
Motion for a favorable has been seconded. Is everyone okay to be recorded in the affirmative? Senate Bill 688 passes unanimously. Senate Bill 688 passes unanimously. All right, Senate Bill 912 has been withdrawn, so this motion is for a unfavorable withdrawn. It's been seconded. Is everyone okay with that? All right, Senate Bill 912, unfavorable withdrawn. All right, let's just go through, let's go start from the top. Senate Bill is Jamie, right? Senate Bill 7.
Senate Bill 7 requires the Maryland Police Training and Standards Commission to develop a uniform citizen positive community feedback process to be adopted and followed by each law enforcement agency. The process must be 1, simple, 2, posted on MPTSC's website and on the website of each law enforcement agency that maintains a website. Each law enforcement agency must maintain a record of positive community feedback for all law enforcement officers within the agency. A record of positive community feedback is not considered a personnel record under the Maryland Public Information Act Notwithstanding any other provision of law, records of positive community feedback are subject to public inspection in accordance with PIA. There are no amendments.
Motions for favorable. All right, it's been seconded. Is everyone okay being recorded in the affirmative? Senate Bill 7 passes unanimously. All right, Senate Bill 15. That's Shamari.
Senate Bill 15 alters procedures for the dispute settlement mechanism on the Maryland Cooperative Housing Corporation Act and makes other technical and clarifying changes. The bill applies prospectively and may not be interpreted to have any effect on or application to any complaint or demand formally arising under the rules of a cooperative housing corporation or the provisions of a member's proprietary lease before its October 1st effective date, unless the bylaws of the Cooperative Housing Corporation or the proprietary lease of the member states otherwise. There is an amendment in your packet from the sponsor, and that amendment requires the governing body to send notice to a violator via certified mail. And this would conform this Senate Bill 15 to the cross file in the House.
The House cross file passed 138 to nothing. So this amendment would just put this bill in the same position as the House cross file. All this does is apply the same settlement procedures to co-ops as currently applied to condos. No opposition, no questions, as I recall at the hearing.
Excellent. You want to adopt the amendment? No, Senator Carter has a question. I'm sorry.
It's a random question to some extent. I think I did ask it at the hearing, or maybe not. Maybe I asked the proponents, but I was just curious because we talked about how these co-ops are very rare. Talked about how I lived in one of them in my experience. So do we know how many co-ops exist in Maryland? How many are we talking about?
I thought they were just in the Tuscan and Canterbury section of Baltimore City, but I understand there's one, that's where you were, right? Right, exactly. I think there's one I heard in Prince George's County and maybe one in Montgomery County.
Montgomery, and
I heard there was one in Garrett from the research that Corman was doing. So I don't know for sure.
Yeah, but they're not many. They're very few.
All right, so we're going to adopt the amendment first. Everyone's okay adopting the amendment? All right, now the bill's before you as amended. Further discussion? Motions for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Okay, Senate Bill 15 passes unanimously with amendment. Now go on to Senate Bill 34.
Senate Bill 34 alters the circumstances under which an individual is disqualified from jury service. The bill repeals a provision that disqualifies an individual who has previously received a sentence of imprisonment for more than 1 year. Instead, an individual is not qualified for jury service if the individual has been convicted of a crime punishable by imprisonment exceeding 1 year and is currently serving the sentence imposed for the conviction, including a term of parole or probation. The bill also disqualifies an individual from jury service if the individual was convicted of a crime involving or relating to perjury, witness intimidation, jury intimidation, or a crime under Title 8 of the criminal law, which deals with fraud and related crimes. Finally, the bill repeals a provision providing that an individual with a disqualifying conviction who has been pardoned qualifies for jury service. There is an amendment in your packets. The amendments add additional crimes to which would disqualify jurors.
It's just a one-page amendment. It's Senate.
Yes.
Is it, I've not seen this before, but 723-121/1. Is that the one?
Yes.
All right.
And
Do you have that, Senator Carter?
I just want to note I think there's a typo in the amendment. It should say bribing a public employee under 9-201.
Got it. What are okay, so 9-201, okay, criminal article, bribing a juror and bribing a public official. Those are the only two offenses that are added?
Yes.
Senator Carter, defer to you.
Hopefully we can finally get this over the finish line. I think it's a really good bill. As I've said many times, I think it ends a vestige of discrimination that we need to end, but it also is a benefit to all Marylanders because it expands jury pools and keeps people from being repeatedly, the same small group of people being repeatedly brought into jury service I can even tell you, can I add something that's just interesting? So I had jury service that I was called to while we've been in this legislative session. And I was able to get it continued, but then they continued it to another date before the session ends. And so in speaking with the jury commissioner's like, sorry, but you don't get any exceptions because you're in the legislature. And I thought that's wild because we get legislative continuances for any cases that we're attorneys in. I actually think that's something this body might consider taking up in the future because we really cannot go and serve on a jury while we're in session. Thank you.
I did too. And I looked up the law and the form, and no exception. Federal elected officials are out. You have to ask, and it is entirely in the discretion of the jury person up there, commissioner, to grant or deny. And I thought that is a weird thing.
Mr. Chairman, perhaps this bill would be more palatable to those few people that don't agree with it if we added that exception for legislative service for jury service.
I would say, I've been asked while I was here, and then the lady on the phone said, well, you can go to jail for this. I said, well, you can come pick me up. I said, but you have to pick me up because I can't drive up there. But they just go back and forth like like it's the end of the world. She said, well, Anthony Brown came and she started naming all these people. I said, I've been there twice. She said, I don't know you. I thanked her. That was it.
Same sort of resistance to it. It wasn't like an easy, oh, absolutely, we understand you're in session. No, not at all. So I'm telling you, maybe a memorandum needs to go out to like explain. I'm just saying.
Just stick it on the bill.
Just like an up.
This session.
See how the same people get called over and over again though?
There's an uprising here in JPR, all right? Senator Kelly and then Senator Sidnor.
I'm so sorry to contribute to this, but I just have to add on the topic of this conversation so that we are aware. It took 25 years for the legislation to pass to allow women to serve on juries in the state of Maryland. It's International Women's Day. So 25 years, once women got the right to vote, 25 years, the judiciary opposed it every single year. It was 1947 before it passed, but that was only in half of the jurisdictions, including Baltimore, though. Half the jurisdictions, 12 counties exempted themselves, and it was throughout the 50s and 60s before women were allowed to serve on juries in Maryland. With that, I would say I agree with Senator Carter on both this bill and also her suggestion that we clarify that session's a really hard time to serve on a jury.
See, now I guess I'm gonna be a little bit more serious. To the maker of the amendment, I'd like to understand why we're suggesting 2 additional crimes and is there statistics that shows that this is an issue?
Well, there are no statistics, but it just seems to me if we're going to allow somebody to serve on a jury, we don't want to be have someone on the jury who's been convicted of bribing jurors. I don't think that needs much more explanation.
Okay, then what about the other?
Bribing public employees. What? I just think there has to be some limit of the people we want to have serving on juries. People convicted of bribing, especially jurors, should not be serving on juries.
Is that an issue? I mean, is that a real problem? Are people bribing jurors?
Well, at the moment, you can't be on a jury if you've been convicted of a crime. So we've never had it. We've never faced the issue. But in the future, if we're allowing people who've been convicted on crimes to be on juries, why would we allow someone convicted of bribing a juror to be on a jury?
I'm just all right. Thank you.
Thanks, Mr. Chairman. I just want to say that I think that the one person in every 50 years that may have such a conviction, I don't think it's necessary because honestly, philosophically, this really depends on like your philosophical ideology about whether you truly believe that a debt to society has been paid once a person has completed a sentence, parole, and probation, whether you think their full citizenship should be restored. I happen to believe it should. And so there's much more heinous offenses even that people could have committed that I believe once they've paid their debt, they ought to be eligible to serve on a jury. Certainly, it is highly unlikely that through the voir dire process, a person that's been convicted of jury bribery is going to be acceptable to both sides of either a civil or criminal case. All of that being said, I think all of the amendments that have been proposed to restrict the persons that can be on here are unnecessary. But in the spirit of moving this legislation forward, I'm willing to accept them all because we are getting a tremendous bonus by being able to add the people, so many thousands of Marylanders to the jury pools. And I think it's going to make for more robust and more diverse juries and a better system of justice. Thank you.
I just want to know, are we adding that amendment to clear us from jury duty? Is it coming or not?
I'm gonna go with no.
That's the next thing, sure. So.
Amendment is before you.
So moved.
It's been moved. Seconded, or is everyone okay adopt the amendment? Or so Senator Sidnor is no. All right, now the bill's before you as amended. The motion's for favorable with amendment. Seconded, is everyone okay being recorded in the affirmative? Excellent. All right, Senate Bill 34 passes unanimously with amendment. Shamari, we're going to stick with you one more time, then I'll give you a little break. Seems like a good time to follow up. With Senate Bill 827. 827.
Senate Bill 827 specifies that the purpose of jury examination in all jury trials in a state court must be to 1, identify and remove prospective jurors who are unable to serve fairly and impartially, and 2, allow the parties to obtain information that may provide guidance for the use of peremptory challenges and challenges for cause.
Great conversation with Senator James. It was a very, very good dialogue yesterday. We want to make sure that we have an opportunity to have a little bit of a discussion. Senator West, did you have anything to say? I did. Oh, no, I mean, just after, I don't know if you had, I thought you had your light up. Yeah, got it. So I'll open up the floor, but Senator James, do you want to say anything, or I can begin some of the dialogue too?
So much better forum to
Yeah.
discuss than it was in the hearing here, because I think there's a lot of miscommunication and we had the judiciary on a conference call, and I can talk about this, right? And interestingly, the judiciary is considering even eliminating sort of the peremptory challenge altogether. And that was very helpful, I think, for the rest of us to say, okay, so what else are you all looking at? And they're looking at quite a lot of things, sort of following New Jersey, New York were the 2 states I looked at that are comprehensively looking at the judicial system, ways to eliminate bias, or mitigate bias, and a lot of other improvements. So, and we did discuss very seriously turning the bill into, or having a separate bill that would create a work group task force to hold the judiciary's feet to the fire to come up with these modern and good changes, but not do it so quickly that they aren't part of the process. And I thought it was a very collaborative meeting myself.
So it's interesting, they're studying a lot. I mean, so the peremptory challenges was, I thought, very instructive.
Right.
And they've done a study. They did a study in 2014 that lasted from 2014 to 2017, and then obviously the one that was 10 years. That was 10 years ago. And then I think they're starting to initiate another kind of. They're talking about. We are all talking about another study as well to do kind of a more comprehensive look at this. So, we could do, we could add a work group or study group onto this. Especially if they're planning to do this, I don't know if they're doing this as well. Like, I don't know what their approach is specifically, but if they're going to do things through rules committee, or if they're going to, Chief Judge Fader, Justice Fader is going to initiate some sort of initiative, a different initiative or route to do it. But we could add that on to this. Senator West.
Yes, I wasn't available yesterday, unfortunately, for this work group because I had bills up in finance. But my thought on this bill was the concern expressed by the advocates was that the trials would become much longer because whether you're on the plaintiff side or the defense side, the lawyers are going to want to keep asking questions until the judge says no more. And then they'll say exception, which will give them grounds for appeal. So my thought was we could solve that problem by adding some language, and maybe we want to hold the bill for a day so I can develop the language more specifically, but I'm thinking the two would say, allow the parties to obtain information that may provide guidance for the use of peremptory challenges and challenges for cause, comma, provided that the judge presiding over the trial shall have complete discretion to, I haven't finished the sentence, but you see where I'm going on this?
I mean, I know that's what they're saying is the case anyway. This is a judge-driven process that they could.
But if we added this, it would
clarify.
stop appeals being taken. Because the language itself would say the judge has complete discretion.
So this has been in the federal system. I know they're not completely analogous, but in the federal system, they're saying that when the judge does this, it has not been a source of appeal. It has not been the practice on this. So we're not apples to apples here, but I'm just saying it's been in place for 8 years. Senator James, can we get Senator James?
The reason I'm hesitant to do the bill as is and like the idea of turning it into a, whatever you want to call it, is a couple fold. They are looking at a much broader array of options, in not only getting rid of peremptory challenges, but also expansive written questionnaires, which I thought were in every court because that's been my experience, but apparently they're not. And then bias training and other things. So what I worried about with this particular bill, with if we did this and the judiciary is going in and going to change peremptory challenges, is that a lot of resources and effort are going to go in to trying to respond to this bill, whether it's to come up with model language for jury voir dire, other guidelines, and the like. And then if the judiciary ultimately gets rid of this whole area of peremptory challenges, that's going to be quite a lot of effort that this suddenly is no longer relevant. Well, that's why I was so taken aback that that the judiciary was telling us that they might get rid of this process and do something else. Made me think that we would be developing a whole new structure for a couple of years, and then it would have to completely change based on whatever the judiciary does going forward. But what I did like about the idea of this bill is that it would, however we use the vehicle, is to compel and make the judiciary do what they've been talking about for a decade or more, which is to improve this system. And this would, I think we could do that with deadlines and the like.
Senator Carter.
Thanks.
First of all, I really think the bill is good as is. I did have a question, I guess, for Senator West, because I just didn't understand what you were saying. You said something about judicial discretion. Judges do have discretion. What additional discretion would you want to add?
Well, my concern was the bill has this mandatory shall word in it. So purpose of the jury examination shall be to allow the parties to obtain information that may provide guidance for the use of peremptory challenges. So the bill now, as a matter of statute, it says that this is a shall process, not a discretionary process, a shall process. And if I were an attorney, I would want to make sure that in any case jury trial, that during the voir dire, I kept asking questions until the judge said no more, that's it. And then I'd say exception. I would preserve a ground for an appeal. And if both counsel did the same thing in every trial, we're talking about a much longer voir dire process than is currently the case, which makes the trials run longer.
I understand what you're saying. I don't think it's really probably too much of a thing that's going to be common. No, listen to me. In my experience, very few lawyers want to expand the voir dire process longer than the arduous process that already generally exists. In fact, many just want to get it over with so they can get to the trial. That's more common, I think, than not, but you know, not that it would never happen. I'm just saying. I like the bill.
Well, the witnesses who came to testify on the bill were quite interesting in their discussion of what kinds of things they would want to inquire about. So I suspect you would find, and they don't relate to cause, they relate to other aspects of the juror's life, which might influence how the juror would vote on the case and would help them with their peremptory challenges. So we haven't had that system in Maryland. If we go to such a system, I wouldn't be at all surprised to find the trials get much longer. And so my language would give the judge complete discretion to say enough, that's it.
So I don't necessarily have a problem with that, at least at first blush, because I think this is an improvement, a potential improvement in our process. But I also just want to say that as a huge fan of the television series Bull, if you have never seen it, it's a must watch. I am so excited about the idea of having a greater ability to explore potential jurors. I mean, it's going to be incredible. But no, nobody wants to prolong it forever, because at the end of the day, all lawyers don't have all year to get a trial done. There's a finite amount of time that people have for it.
Thank you, Mr. Chairman. I'm sensitive to the logistical concerns that have been raised here, and obviously we need to work them out. But I just want to bring this back to the values, because I was touched by the hearing. When lawyers don't have a lot of information, they start to base decisions based on prohibited factors, because that's the only information they have. And so when you can't ask questions, or you can't allow the judge to ask questions to find underlying information, people are going to rely on stereotypes. And some of those stereotypes will be based on physical appearance and religion and other factors that we don't want lawyers to consider. And they're going to rely on those factors, not because they're bad people or racist or discriminatory. They're going to rely on that information because they're human beings. And they use the information that's in front of them. And the only information that they have in front of them is the stereotypes that are built into their life experience when they're making these decisions. And so I just don't want to get too far removed from the concept behind the bill. I know obviously we have to get the logistics right, but the current system is broken because it incentivizes the behavior that no one around this wants incentivized in the system. And so I just, before we kind of move on to the next bill and figure out our way forward on this, we just have to remember why this bill is coming forward. I think it's a really important bill.
And when I made my comments, my comments are not against the merit of the bill at all. What I was struck by was when I looked at New Jersey and New York, and I think there are others, is rather than put a bill like this in and have a statute, those states comprehensively dealt with a lot of issues surrounding bias, expanding jury pools and the like. And while I don't think we could do that in this bill, I'm much more in favor of allowing a collaboration between the legislature and judiciary with hard deadlines, basically to say either, we're going to do something like this bill, or you all are going to get rid of, peremptory challenges, and but within a reasonable amount of time, there'll be a collaboration between the two branches of government, and we will move this whole process forward. That's really, it's just for me, not rushing in and doing a bill, and then finding out that bill does no longer works with regard to what the judiciary is doing, which is a massive undertaking, and they can't explain what happened 10 years ago about why they didn't finish out doing this bill and several other things, and I'm not going to infer anything untoward about that, but it's clear from what I heard that they absolutely understand that they need to modernize and improve and the jury system and some other aspects of the court. I just would like it to be more collaborative and not get ahead of them. Thank you.
All right, excellent. So I'm gonna take action on this today, but I want to we'll put it down, a couple of bills down, and getting just a little bit more information and then we'll come right back to it. But I am interested in moving this today. So we'll put a pin in this right now. We'll move on to the list. We're gonna go Shamari. Do you want to take a break here or you want me to move on?
I'm good.
Okay. All right. So Senate Bill 46.
So Senate Bill 46, we've already voted. It just hasn't been reported. There's
Thank you, Mr. Chairman. I can dispose of this quickly. So Senate Bill 46 is a very straightforward asbestos disclosure for condos. When you buy your house, you have to disclose asbestos, but that's not true for condos. We're a little bit stuck here, and so I just encourage the advocates to get together. There's an amendment that would that the Consumer Protection Division of the Attorney General supports that would accidentally and unintentionally create liability for condo boards. That's not the intent of the bill. There's an amendment that the condo board supports that would accidentally and unintentionally create immunization for the condo board. And so I would just say this is a pretty straightforward bill, and we need everyone to kind of get together, figure this out so that we don't accidentally either immunize or create liability that is not intended in the bill. So we're going to hold the bill.
That's right. Ask for a hold. It's a hold. All right. We're gonna go down to give Shamari a break. We're gonna go down to Josh, Senate Bill 182.
Senate Bill 182 establishes requirements, procedures, and prohibitions to govern the use of facial recognition technology by law enforcement agencies and courts. There is an amendment in your packet. It's number 743825/1 from the sponsor. The amendment simply adds information on age, race, and gender to a reporting requirement that was already in the bill for law enforcement who uses facial recognition technology. Besides that amendment, the bill is identical to Senate Bill 192 of 2023, which passed the Senate unanimously.
There's been a motion, but I want the sponsor to have a quick moment to say something. Sidnor?
And this is just so you all are understanding, what this amendment is also doing is ensuring that this bill looks like the House version of the bill. The opponent, everyone that I worked with we spoke with Scott Schellenberg as well as the advocates who were looking for this change. Everyone was in agreement, so I just wanted to make sure you all had context.
All right. The amendment has been moved. It's been seconded. Is everyone okay adopting the amendment? All right. And now the bill is before you as amended. The motion is for favorable. It's been seconded. All right. Senate Bill 182 with amendment passes unanimously. All right. Josh, I'm gonna go with you one more time.
Senate Bill 315 establishes increased penalties for a driver of a vehicle who fails to yield the right of way in a designated bike lane or shoulder to a person who is lawfully riding a bicycle, electric personal assistive mobility device, or motor scooter if the driver contributes to a crash in the designated bike lane or shoulder. A violator would be subject to imprisonment of up to 2 months and a maximum fine of $2,000. There is an amendment in your packet number 113320/1 from the sponsor. The amendment would limit the bill or the increased penalties in the bill to violations that contribute to the serious physical injury or death of the person riding the bicycle, the EPAMD, or the motor scooter.
So yes, so this amendment, which actually also was put on in the House version of the bill, limits it so that there has to be physical injury or death caused. So I would move the amendment.
The motion's been moved. It's been seconded. Is everyone okay? The amendment? All right. Now the bill's before you as amended. Further discussion.
Sorry, move the bill as amended.
Motions for favorable with amendment. It's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 315 passes unanimously with amendment. We do Senate Bill 402.
Senate Bill 402 alters the membership of the Correctional Training Commission by repealing the representative of the Federal Bureau of Prisons, by increasing the number of members appointed by the governor who are correctional officers from 4 to 5, by repealing the requirement that one of the 4 correctional officers appointed by the governor be a Department of Juvenile Services employee, and by specifying that the 5 members appointed by the governor must be from local correctional facilities and represent each geographic region of the state.
Seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 402 passes unanimously. Josh, keep going with you for a little bit, okay? All right. Can we go with Senate Bill 345?
Senate Bill 345 establishes the Vision Zero Advisory Commission to advise the Department of Transportation on best practices intended to eliminate deaths and serious injuries on roadways in all modes of ground transportation using data-driven prevention strategies with an emphasis on a safe system approach. The Department of Transportation would provide staff for the commission.
It's pretty straightforward. Motion for a favorable has been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 345 passes unanimously. You want to just keep on? Let me do for Senate Bill 504.
No.
Senate Bill 504 establishes a new regulatory framework applying to recreational vehicle manufacturers, distributors, factory branches, and dealers. The bill is identical to a version of House Bill 1173 of 2023, which passed the Senate unanimously.
So the motion for favorable and seconded with further discussion. Is everyone okay with that? I'm just giving everyone time to catch up. All right, is everyone okay being recorded in the affirmative? All right, Senate Bill 504 passes unanimously. We'll do that. Hold on. Let's just do Senate Bill 544.
Senate Bill 544 alters statutory provisions under the Corporations and Associations article regarding the ratification of defective corporate acts, which were enacted in 2022 by Chapter 290.
It's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Yes. All right, Senate Bill 544 passes unanimously. Jim, we're gonna go Jamie real quick.
Sure.
So let's go to Senate Bill 608.
Senate Bill 608 requires a law enforcement agency to file any administrative charges arising out of an investigation of alleged police officer misconduct that is not required to be reviewed by an administrative charging committee within 1 year and 1 day from the date of the incident that led to the investigation. However, if alleged police officer misconduct is related to activity that reasonably appears to be the subject of a criminal investigation, an administrative charging committee or law enforcement agency must file any administrative charges within 1 year and 1 day of the date of either the investigating law enforcement agency's determination that the matter is not related to criminal activity, the final disposition of all related criminal charges, or finally, the administrative charging committee's or law enforcement agency's receipt of notice that the appropriate prosecutorial authority declined to file criminal charges. There are 2 amendments in your voting packet. The first amendment is amendment number 343-529/1. This is an amendment from the chair. It alters the tolling provisions of the bill to incorporate language that was suggested by David Roca from the ACLU. And it connects the tolling to when an appropriate official employed by a law enforcement agency becomes aware of an incident. The amendment is a little unlike the amendment that the committee considered last week. It is similar, but it makes the exception for criminal prosecutions apply to both ACC and non-ACC charges. And there's a second related amendment that I can get into as well, and discuss the difference.
Good. Is that? Make sure.
This
is what we discussed.
Yep.
Yeah.
All right, so let's just move this amendment then. Seconded, okay. Now the bills before you as amended, they're.
Does that sound good and technical clarifying?
Substantially, it's amendment from Senator Sidnor. It's amendment 573-226/1. Like I said, it's substantially similar, but it adds an additional suggestion from Mr. Roca that the limitations period also toll 1 year and a day from the date of judgment in a civil suit.
So I appreciate the idea of behind the amendment, but the amendment would create a problem because civil actions go on forever, and civil actions are not dealing with the action. You could have an officer potentially under investigation for his entire career if there's a civil suit brought forward, and then the department's stuck on how do they put them back out on the road? Do they keep them off the road, pan them? So this amendment doesn't stop somebody. It doesn't stop someone, or it doesn't help someone in a civil suit. They can still file a civil suit, and the civil suit is not a criminal act. If anything arises out of a criminal act, then it's already been handled under the First Amendment. But this one adds a burden on the unnecessary burden, not only on the employee, but on the agency to decide how they're going to handle this person for a civil act, which anybody can file a civil claim at any time. So I would not consider that a favorable amendment.
All right, further discussion. Senator Sidnor, you want to speak on it, or? Okay. Since there's nothing, there's been no motion right now. I just want to make sure that since we adopted the amendment we just adopted, we want to remove the amendment from last week. So that's amendment 833-827/1, which is. It was your prior amendment. The law enforcement agency became aware of the.
Yeah.
Right, that was for the non-ACC.
Yeah.
Added back.
Yeah,
Right.
it's subsumed into it, but we still need to remove this. Okay, so there's a motion to remove this amendment. Second, is everyone okay doing that?
Yeah.
Okay. Here we go.
Thank you.
All right.
And absorb it at the same time, listening to what Senator Folden said. And can you just repeat it? Because when you were saying what you were saying, I didn't have the amendment.
That amendment does nothing as far as, whether a person can file a civil action against an officer. But what it does is it puts an officer and the agency in a precarious position that on what they do with the employee pending civil litigation, because what this says is that really the investigation doesn't have to be done until the civil action is finished. And civil actions can take forever. They can take 10 years or longer. So there's no right to a speedy trial, which is given to every other citizen in our judicial system. But police officers trying to get their speedy trial within the confines of the agency completed is now gone. And they could be on the sidelines for a decade or longer. Yeah, and the one that we just moved was allowing that the agency, once they become aware, and Jamie, correct me if I'm wrong, but I know we discussed this yesterday. So this was another one that came from the ACLU about that once the agency becomes aware that. So the problem is right now is in MPAA, it's written as a year and a day, period. The problem with that is if the officer, the alleged officer is involved in what would be considered, or they get indicted or there's criminal activity, the way it's written is you've got to make an adjudication prior to any action that's in the courts. And that goes contrary to how this is supposed to be. You can't take an action against an officer before this is adjudicated or the police integrity unit of the state's attorney's office makes a decision on whether or not they're going to indict or they're going to send it back to the agency. All that time, the clock is ticking. So if we by adopting the amendment we just did, it says that once the integrity unit of the state's attorney's office makes their decision, if they decide to send it back, now the agencies will put on notice that they can move forward, and it's a year and a day to finish the investigation, to include the adjudication of a trial board. If they decide to go to charges and it goes to court, I mean, everybody's more than familiar. You can delay, you can ask for continuances, and that can delay this beyond the year and a day that's in place easily. Then if they're not found not guilty in court, the agency has no recourse to go and charge this person by the way this is written right now. So this allows the agency to wait for the adjudication of the charges in court. And then once that disposition is made, their year and a day begins on how they handle the employee side administrative charges of the employee. That's what this bill is about.
Got it. Senator Sidnor.
Got it. Now the bill's before you as amended. Motions were favorable.
Second.
We did not move that amendment. Favorable with amendment. Is everyone okay being recorded in the affirmative? Good. Senate Bill 608 with amendment passes unanimously. Yes, we go to Senator Carter. We go to Senate Bill 730. Oh, sorry, hold on one second. Senator Folden was going to hold back open. Senator Folden would like to be a co-sponsor of Senate Bill 608.
Senator West.
Senator West with Senator Folden. Yeah, you are the sponsor. You would like to be all right. Is everyone okay with that amendment okay? Great. All right, we're going to go back to Josh with Senate Bill 730.
Senate Bill 730 prohibits a motorcycle passenger from riding on a seat at the rear of the operator if the passenger cannot position their feet firmly on the footrest while seated. The prohibition does not apply if a passenger cannot position their feet as required due to a permanent physical disability. A violation would be a misdemeanor subject to a maximum fine of $500.
Motions were favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 730 passes unanimously. We're now going to go on to Jamie with Senate Bill 549.
Senate Bill 549 exempts from statutory provisions relating to the use of forensic, genetic, genealogical, DNA analysis and search, otherwise known as FGGS, conducted solely for the purpose of identifying an individual younger than age 18 who is either deceased or is the subject of a missing person report filed with a law enforcement agency and whose whereabouts are unknown. There is a copy of the House crossfile, which is HB 549 in your voting packet. It has marked on it SB 549. Oh, here we go. I got it. Right. The House version as amended made the bill apply to all missing or deceased persons, not just those under the age of 18.
That's the amendment. So yes, yeah, there you
And
to conform to the House, yeah.
just a correction, it's House Bill
476, yeah. All right, now the bill is before you as amended. Further discussion. Motion is for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 549 with amendment passes unanimously. Let's go to Senate Bill 666.
Wait a minute, which one?
Do that 666.
I would say that Senator Carl's office just sent an amendment for that one. So I don't know if council's even seen it. Like, while that we were in voting.
Oh, hold on one second. All right, we were just.
Just making sure the bill matched with the House bill. So,
And the House bill's moved.
yeah,
So we can
Vice Chair,
conform.
HTO is good.
We're gonna hold this to the afternoon just so council's prepared. All right, I just gonna make. Oh, it is. It is.
Okay. It's the same. Yeah. It's the same amendment we heard at the hearing.
Oh my
Yeah.
God, if we didn't.
Don't put off tomorrow, what you can get done today.
I would like, I did we move 66? I can't even say it, but that one. I did an
66.
amendment to conform it to the House version, which we heard at the hearing, and I think it's ready to go, so I would like to move it or second it if
Yeah.
my friend would like to move it. No, we had that, it's the
It's in
same
your
amendment
packet.
from the
It's the
hearing.
same amendment.
All right.
It's 641.
I like that. All right. Just take a beat, look at the amendment. Can you explain the amendment? It just conforms the House, but what does it do? Just explain.
So the amendment, it lowers it rewrites the bill, but it was the result of some discussions had with, I believe it was the National Federation of Independent Businesses. There was a bill in 2020 that was identical to this bill as amended. But what the amendment does, it allows the Maryland Commission on Civil Rights to award monetary relief to a complainant and kind of sets the limits of how much money. It raises the amount of money that was originally able to be imposed as a civil fine and instead allows that money to be awarded to a prevailing plaintiff. And the amounts are $500 if a respondent has engaged in her first act of discrimination at a place of accommodation. And if there's been one other act within 5 years, it allows a $2,000 award. And if there have been two or more within 7 years, it allows a $3,000 award.
So it's 1,000.
2,000, 3,000.
500.
Oh, I didn't see. I thought it's
2,000.
bracketed out. I'm sorry. Am I reading? It looks like 1,000, honestly.
I'm sorry, it raised it from 500
Yeah,
to
yeah, yeah.
1,000.
Okay. All right.
Look at it, it's in mine.
Senator Kelly.
Want to remind the committee that we heard testimony at the hearing from the Restaurant Association that reflects exactly what Shamari just said to us, that there was an agreement in 2020 And I'll just read the language from their letter. So we worked with the sponsor of the House version of the cross-file to amend the bill to reflect the 2020 language that all the stakeholders had agreed to with other minor amendments. And so that's the version that the Restaurant Association was comfortable with. So I'm thankful the sponsor is amenable to that amendment.
All right. We adopt the amendment yet? Can we adopt the amendment? All right, now the bill's before you as amended. Further discussion? Do you have a motion?
Motion to accept the bill as amended.
Okay, motions for favorable. It's been seconded, so now motions for favorable. Is everyone okay being recorded in the affirmative? All right, Senate Bill 666 with amendment passes unanimously. All right, we're gonna Shamari, can we go to Senate Bill 344?
Senate Bill 344 creates exceptions to criminal prohibitions against trespass on property under Title 6, Subtitle 4 of the Criminal Law Article in the Common Law Tort of Trespass for a professional land surveyor or an agent or employee of a professional land surveyor who enters the property of another to practice land surveying. There are no amendments.
I think we passed this unanimously last year. Yeah, motions for favorable and seconded. Everyone okay being recorded in the affirmative. Senate Bill 344 passes unanimously. Okay, Shamari, let's go back down to, we got some good news. All right, to Senate Bill 827. So in consultation and with discussions, especially with what we had yesterday with Senator James, so I'm going to make an amendment, and I think you can do this in line, but it's just to add a work group. You have DLS, OAG, and the judiciary to study the voir dire process. We'll have it sunset in a year.
OAG, GLS.
And the two representatives, so two representatives from DLS,
From the legislature.
from the legislature, so someone from the House, someone from the Senate. There you go. Yeah, that'd be cool. One from the OAG, two from OAG, and two from judiciary.
2 Senate members and 2 House members, or just 1 Senate, 1 House?
One and one.
Okay.
No, it's just with it. Yeah.
So just
Two representatives, what section? Just any bar, just the bar section? One
From MS.
Oh, yeah, this is, I think just keep it the 3 branches.
So DLS is staffing.
All 3 branches are providing staff.
Okay. But there's no DLS member serving on it.
No. DLS doesn't.
Mr. Chairman, I, with the part of the bill that as it originally came in, I don't know if you had thought about it. How does this bill roll out in the judiciary? It'll have an effective date of July or October. And I guess if we pass that part of it, then in a few months, the judiciary has to figure this all out, right? How they're gonna change this whole system throughout the state. And what questions are, I'm just trying to figure out how you think it's gonna, how somebody thinks it's gonna roll out without giving them more time.
So you could make the task force a July task force to give them a little bit more head start. Admittedly, it's not years or so. You could make that effective July 1st and have it, the bill will go into effect October, giving them some time. Admittedly, though, I mean, they have studied this extensively already, and even for the model questions, like they have forms, they have all that stuff kind of that was generated from that 2014, 2017 study. I'm not quite sure it's gonna take a long time, but I do think there should be collaborative efforts with all three branches. So if you think July would be a better, give them a few more months.
I was just thinking of trying to get the work group a little ahead, but I didn't realize that. I asked about the 2014. I didn't know they had developed model voir dire.
That was what my understanding is. They had, there are examples of these model questions that I guess you've experienced in some courthouses. So a lot of this material has been developed and, thought about deeply, but.
That I didn't realize.
Yeah.
That's all I'm saying. So, but anyway, if we could figure out a way that group could at least get
Start
constituted, working, knowing and working up toward an October.
July
start
1st. Yeah.
date. Would that make sense? Something like that.
Yeah, we could do that July 1st,
For what?
for the work group, ahead of the effective date of the actual
Yes.
bill.
Yes.
Yeah.
And so, Mr. Chair, I'm sorry.
Go ahead.
So which, just for the record, who are the members of the work group?
A member of the Senate, a member of this House. OAG,
As two.
2 from OAG, and 2 from Judiciary,
And who appoints the members?
Speaker and Senate President.
And then.
And then
Judiciary and the,
Chief Judge, and the Attorney General.
and then OAG, DLS and Judiciary, all staff.
That's right.
And the work group is to study and
Voir dire.
voir dire process in the state of Maryland and to report its findings and make recommendations to the General Assembly. Okay. Effective July 1. We got it.
Thank you, Mr. Chair. So I just want to make sure that I'm clear on this. So when I read the Maryland State Bar Association letter regarding this bill, they talk about the vagueness of the proposed jury examination process, which I think you've just kind of solved. But they talk about the impact on judicial discretion. And is that what Senator West was trying to get at with his proposed amendment? Yep. So I think that, we've, being good stewards that we are, you've found a solution for the one part of their concern, and this is the largest representation of attorneys in our state, I'm gonna guess. And I would think that we would want to put something to kind of codify and address the judicial discretion and the impact on it through the language that Senator West was requesting, because I don't know that it does anything except make it stronger.
I don't think it's necessary. I mean, look, I'll point out that as is, 13 bar associations across the state have endorsed the bill as is. It's look in your bill file, 13 bar associations.
So what's the negative part of doing the bill? I mean, you're saying you don't think it does, but when we always have like the unintended consequences, what is the problem by adding that language would be my question.
Which language specifically are you referring to?
The one that Senator West.
Can we hear it again?
Senator West. He's asking.
Let me find it. You'd add the language, I finished it up, but provided that the judge presiding over the trial shall have complete discretion to control the nature and length of such jury examination.
Why is that? Explain that again.
Read it again.
Tamari, look, that is the case anyway.
Yes, under current law, established by case law, the judge retains wide discretion in determining the voir dire, and the purpose through the case law is that first prong.
But here's the deal. Like, I got what you're saying. I think it's the case anyway. Does that change anything? If we put that into statute, is that going to change anything? Just saying that the judge has to.
I believe it would just be affirming what's currently in case law, that the judge retains discretion.
All right, so.
I think it just gives greater clarity.
It's saying that it's literally saying that the judge has discretion.
Right. Right, but the statute, my problem is the statute we're about to pass uses the word shall, which arguably impinges on the court's right to disqualify. It says the purpose of jury examination shall be to allow the parties to obtain information that may provide guidance for the use of peremptory challenges. So once the statute says shall, there's some question as to what discretion the judge has to stop them from doing what the statute says they shall have the right to do.
I'm not sure there's any state that have anything like this. And that's one of the reasons.
Senator Kelly.
I'm sorry, I hope I'm not distracting and is rather focusing the conversation, but weren't we discussing doing a work group, like to be a companion? I see. Thank you.
To the bill, but only makes it stronger.
And so I think Senator West makes a good point. I think there's gonna be arguments that the attorneys have discretion, but ultimately in the trial, the judge is the arbiter of whether or not, something would fall under a strike for cause or a strike for intelligent peremptory strike. So
All right, I'll adopt, I'll accept the amendment. Okay. Is everyone okay?
So the amendment would add at the very end of subparagraph 2 of subpart B, comma, provided that the judge presiding over the trial shall have complete discretion to control the nature and length of such jury examination.
I mean, in every trial, the judge, as Shamari said, is the ultimate arbiter. So almost every issue is ostensibly appealable. It's just whether or not there was an abuse of discretion and other things like, so I don't see the need for it.
I think you're right.
All right, after further conference, I'll withdraw the amendment that I'd proposed and instead suggest that we take out the word shall and substitute the word is.
Shall be.
Is to be. The purpose of examination is to. Exactly.
Is amendment. It depends on what your definition of is. All right. Yes. Is everyone okay with that? All right. Now the bill is before you as amended. The motion is for favorable.
Nope, you gotta amend the work, you gotta add the work group.
We add we added the work group?
We did not formally vote on it.
Can we add the work group? Motions for favorable on that, is everyone okay? Effective July 1, motions for favorable with the two amendments? Yeah. Is everyone okay being recorded in the affirmative? Okay. Senate Bill 827 with amendments passes unanimously.
One second, I'm just pulling it up. Senate Bill 839 defines damages or losses and statutory causes of action to protect civil rights or consumer rights, and provides that damages or losses includes reasonable nominal damages.
All right, so motions for favorable has been seconded. Is it further discussion? All right, hold on, just give people time to read it, catch up on it. Senator West.
I guess my question, I hate whereas clauses. They don't become part of the statute. Why do we have all these whereas clauses in here? Are they needed?
I think it helps, when people go back to look at the legislative intent, it actually, even though it's not specifically that, I think it helps them to understand what the intent was behind it, or the impetus for it, so. I think
Is the language of the statute ambiguous? Why do we need legislative intent on this?
because people always try to figure out what was the intent behind what we did. I don't know what, sometimes it does appear, it depends on the, it's situational.
It's, okay, just in general, I'm not wild about whereas clauses.
Okay. Right.
I'm just looking at, again, the State Bar Association letter, and it talks about it may cause confusion about what types of claims would be entitled to nominal damages. I guess they recommended deleting the one paragraph, given the bill's goal of codifying nominal damages from existing case law. This would result in the clear inclusion of reasonable nominal damages in damages or losses. So was that anything that was discussed or addressed? Yeah, it was.
And the thing that puzzled me about it was that the definition that was used came out of a dictionary that lawyers use called Black's Laws Dictionary. And that was the definition of damages. So what they're saying makes no sense.
All right, so there's been a motion for favorable, it's been seconded. Further discussion? Is Evan okay being recorded in the affirmative? All right, Senate Bill 839 passes unanimously. Let's knock this out real quick. Senate Bill 71 is on hold. We're waiting for B&T. So on the first page, 71, Senate Bill 92, we're still working out, so that's on hold. Senate Bill 102 is on hold. Senate Bill 118 is on hold because we're waiting for B and T, but it's all queued up and ready to go as soon as we get approval. Senate Bill 139 is on hold because we're waiting for B and T. Senate Bill 134 is also on hold. Okay, yeah. Do you want to just go ahead and go into that? Because I thought it was a good discussion. The work group had an opportunity to do. You want to just describe that and then we're waiting for B and T, but you want to describe it?
So Senate Bill 134 establishes the Correctional Ombudsman Unit. So as drafted, it would be in the Office of the Attorney General, but there have been discussions to create an independent entity to house this and potentially the Juvenile Justice Monitoring Unit which is also currently in OAG. There are some ongoing discussions about how to fund the unit, which is the holdup over in B&T. But substantively, the unit would be very similar to what it was in Senate Bill 87 of 2023, which the Senate passed.
Senator James.
So, can you say that again? If we do this, we might also have an ombudsman for juvenile services also, is that, what did you just say? Follow that.
So the vision would be, so JJMU, the Juvenile Justice Monitoring Unit, is currently within the Office of the Attorney General.
Yes.
That would be taken out
Yeah.
and put into this separate entity, which would also house the Correctional Ombudsman.
Is this similar to sort of that independent entity to get juvenile?
Correct.
That's what.
Yeah, and it would
Okay.
be vested
Very
with a few more. So the topics have been talked about. So now the Correctional Ombudsman has subpoena power. The thought is to give the JJMU the same thing.
Got it.
All right.
Good. All right.
So I think in concept it's done, but looking for funding.
So we're waiting
Yeah,
for
for
money.
that first year, I think in particular.
Do you have, will we have a copy of language anytime soon, like maybe next week or something?
Yeah, I think we have, I can distribute some language. It's not finalized yet, but it should be close to what it ends up being.
Did we ever come to an answer to my question? Somebody fails to comply with the subpoena, what happens?
Yeah, so I was looking at some other entities in the code who have subpoena power, similar to that, where it's kind of not necessarily as part of an ongoing case, but as part of their own internal investigations.
Right.
And that some of them have language that specify that, if someone defies a subpoena, they can, go to circuit court and initiate an action to enforce the subpoena.
But this bill doesn't say that.
It doesn't have that language explicitly, and we could look at adding that to the bill.
I think we should. Otherwise, it's just up in the air as to what would happen. There's been nothing provided.
Yeah, well, I'll relay that to the drafter of the amendment and
Okay.
we'll get that worked out.
So that bill's on hold. All right, let's go. Just to round this out, Senate Bill 282 is also on hold because we're waiting for a B&T. Jamie, is 287 ready to go?
Yeah, that's good.
All right, let's go Senate Bill 287.
Senate Bill 287 is a departmental bill that makes technical and procedural changes to the licensing and certification process for private detectives, security guard agencies, and security guards, and to the commissioning process for special police officers to facilitate automated processing of application and payments. There is one amendment in your voting packet. That is Amendment 133128/1. The amendment makes the bill identical to House Bill 172, which is the cross file as amended by the House. The House bill is currently on second reader in the House. The amendment and the House amendments added a couple of agencies that get licensed by Department of State Police, but were unintentionally omitted in the original drafting.
I'd like to move the amendment. And a second, is everyone okay? All right, now the bill's before you as amended. Further discussion. It's been motioned for a favorable with amendment. It's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 287 with amendment passes unanimously. All right, we're gonna break here, but when we come back, we're gonna start off with, we're gonna come back, yeah. We're gonna come back on the rest of the, we're gonna start with Senate Bill 905, okay? When we come back. Right after floor, just so we can get out of here. All right, how busy is floor today?
The budget, right? Do you want to
Gonna
also?
give like maybe like an hour after floor.
Yeah, maybe I was gonna say an hour after floors have lunch, but how late? All right, here we go. Let me ask you this. We can eat here, but so we're gonna come back. Let's do, all right, half an hour after floor, get your food. Half an hour, 30 minutes after floor, we're gonna come back. Bring your food here, we'll vote, we'll eat, and we'll get out of here. All right. God willing, half an hour after floor. We'll come back. All right. It's crazy. All right, see you on the floor.